Troy Mishler.
Yeah.
So let me pull up Odyssey. Just give me a moment.
Yes, ma'am.
All right. So on this case, do you have all of the discovery?
We do, Judge.
Okay. And has she tendered an offer or no?
We have an offer. We're going back and forth on that, Judge. Today is the plea deadline. But I don't, because she's in trial, I don't think we're in a position to submit that to the court.
All right.
So
We're gonna extend your plea deadline date, and this will be the final plea deadline date. Excuse me, does anyone remember the special prosecutor on Mishler?
It's Miss Crespo.
Oh, okay.
It's Miss Crespo.
All right, didn't she say she was gonna be on vacation at some point?
Yesterday. And the day you gave her was August 4th, I think. And she said she not to send someone else.
I know her schedule because we've been talking quite a bit.
Okay.
She's in trial this week, Judge, and then the next week she's out. So our opportunity to talk and nail down the moving parts would come presumably after she's back,
And when is that?
after next week. So
The week of August 4th?
The first is Friday,
Yes.
so that would make, she'll be out that next week, so it'd be the second week of August is when she's back, Judge.
All right, this is an old case. And I know it's not an old case in the sense of when it was indicted, but this will be your final deadline date. There will be no further extensions. So you all have to confer off record. Norma, can you put this for August 12th as a final deadline date? Will you be here or no?
I'll be coming back from Louisiana that day, Judge, because we're moving my son to Tulane.
Look at you. I should hold that against you. LSU is right down the road and you're doing Tulane. Okay.
So we just have even a few more
What
minutes.
do you feel about Tulane as opposed to becoming an Aggie?
I think it's a good fit for this. For my younger son, it's a great fit.
Awesome. So when will you be back?
We'll be back the 12th.
All right. So Norma, set this for August 14th.
I'll be here, Judge.
All right. Safe travels.
Thank you.
Once you sign the reset form, you're excused.
Thank you.
All right, thank you.
I'm covering that for Joanne De Hoyos.
All right. Are they on bond or in custody?
I verified they're on bond and prior to putting bond, I had done a backfill letter to the jail.
Mhm.
I know he's with the company bond. But we faxed a letter to the jail. There's no way, couldn't get that letter with our contact information and we scheduled a jail visit. But I don't believe it showed to that. I don't have my laptop with.
All right. And so, and the bondsman has no idea?
If you would like me to.
I mean, do you want to call them to check in with them? And then, or if you want it heard now, I'll hear it now.
I can call in, but I would have to come back later this morning, fairly busy.
Sure. Okay. Adriana Ramos?
Mr. Sullivan present, Your Honor?
Yes. All right. So there's a motion to withdraw?
Yes, ma'am. She called me yesterday. She wanted me gone, and that's fine. She wants a new lawyer. I hope the court can give her one.
Well, I mean, is she going to hire an attorney?
No, no, ma'am, that's not what happened.
All right. What's going on?
I had to call the MAC number yesterday for the second time. I've been having many problems with Mr. Boyd. He's very unprepared when we come to court.
Mhm.
The
Well,
first,
just 1 second. Let's do this. So I'm going to have you remain, and I'll have managed to sign counsel come down.
what does that mean, ma'am?
Oh, the MAC attorney is going to come down
Okay, yes, ma'am.
so they can see what's going on here.
Yes.
All right. Thank you. Just have a seat, okay? All right, Norma, can you have managed to sign counsel come down, please?
Yeah.
Court is calling 2025 CR 005379 State versus Adriana Ramos. Could I have parties announced, please?
That's all, Ms. Miles.
Adriana Ramos.
All right, so it is the court's understanding that your attorney has filed a motion to withdraw. Are you aware of his motion to withdraw?
Yes.
All right, so I don't do ex parte. However, managed to sign counsel just sent an email to the court coordinator, and the court is in receipt of that. Any objections to the court reviewing what managed to sign counsel has sent?
No, Your Honor.
All right. All right. So the email that has been sent to me, and I want to explain to you, Ms. Ramos. Normally, I do not allow motions to withdraw just because there's some sort of lack of communication, but based upon what managed assigned counsel has sent, I will grant the motion to withdraw. All right, you may be excused.
Be available for the next council with any questions, John.
All right, if you will just remain in court.
Y'all look.
Thank you. So then the next question becomes, could you raise your right hand for me, please? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Amen.
All right, you can lower your hand if you'll state your name for the record.
Adriana Ramos.
All right, so Ms. Ramos, the questions I'm going to ask you, it has absolutely nothing to do with the facts of your case. Please do not tell me anything about the facts of your case because your attorney would not want you to, okay?
Yes, ma'am.
All right, so are you able to afford a new attorney?
No, ma'am.
All right, do you have any funds in a bank account, any savings?
Not really. My mom just passed away in May, so I just had to bury her.
Okay.
I do have a job at AutoZone, but it's part-time.
Okay, so do you have any money in a savings?
No, ma'am.
All right, so I'm going to have a new attorney appointed to you, and that new attorney is going to be Orlando Castillo. All right, so if you'll confer with him.
Yes.
All right, she's set today, we're off the record. She says today for a just discovery, it's just discovery today.
Okay.
So that's what we're here for.
Okay.
So he'll confer with you and then he'll confer with the state and then he can approach me when you're ready.
Yes, Judge.
Morning, Judge. I'm present on that case.
Right, good morning.
How are you, Judge?
Oh, I'm doing great. Have you conferred with the state?
I have, Judge. They were going to look at their file and then we were going to discuss the case further. The only thing that I believe that I may be missing is some cell phone video that's referenced in some of the reports, but I can confer with the DA on that.
All right, state, do you have cell phone videos on Corbin Levi Samansky? He's on page 3.
You not know.
All right.
You checked though.
Okay. All right. Ms. Ferguson, set this for discovery and state this will be set for discovery in 30 days.
Yes.
And counsel, at that 30-day time period, if you have not conferred with the state before that time period, you'll need to be in court.
Sure, Judge. I apologize if I was supposed to be there this morning. I talked to
No. You can appear by Zoom, but I want to make sure that there's communication between the defense and the state.
Yes, Judge. Absolutely.
All right, Ms. Ferguson, what date? All right, so we're going to come back on August 28th for discovery. Mr. Saminsky, I know that you are at work, so you can appear by Zoom.
Judge, I've got a conflict. I'm going to be in Tennessee on the 28th. Is there any way to do that earlier that week?
What are you doing in Tennessee?
Judge, I'm on vacation starting the 28th, the morning of the 28th. I leave on an airplane to Tennessee to go play golf.
See, people, people tell us these things and then, I don't know, we're sort of jealous.
I
But
know, Judge, I apologize. I didn't want to say it, but you asked me.
all right, Norma, if you can, when do you leave?
I leave on the morning of the 28th, so I could do it the day before, which is the 27th.
All right. Norma, can you put this then on well, aren't you going to be packing on the 27th still?
Judge, not really. I just got to throw my golf clubs and some shorts in a bag.
Okay, all right. We'll put it on the 27th. Norma, is the 27th a good day or no? All right, so let's do it the 26th then. Is that a good day?
Yes, Judge.
All right, we can do it for the 26th. Wednesdays are usually when we're in trial.
Okay, perfect. I'll see you guys on the 26th and I'll reach out to the state.
No, he's still here. All right, so it'll be the August 26th council.
Thank you, Judge, very much. May I be excused?
Yes, you both may be excused.
Thanks, Judge.
Thank you. State and settle. I'm sorry. Thank you.
Oh, us?
Yes.
Yes, Judge.
Hello, Hunter.
Hello, Judge.
Hi, so what is happening with these other cases?
Which other cases, Judge?
On Campion, I have a 2025 CR 007-085 and some PF cases.
Or
Oh, do you know what? You all are not on Valerie Campion. You're on Settle. I'm sorry.
I'm on that one, Judge.
All right, just give us a moment, counsel.
I was like, oh shoot, I don't remember those, Judge.
I was like, I don't remember those
I can
either.
update you, Judge.
Okay. I was like, what is happening with all these cases? All right, if Ms. Settle will come forward. All right, court is calling 2025 CR 0000240 and 2025 CR 013090. State versus Elizabeth Settle. Can I have parties announced for the record?
Hunter Morris for the state.
Will Brooks for the defendant, Judge.
All right, and you're Miss Settle? All right, we were here on July 28th. The court ordered you to have a drug testing done, and that was completed. Is that correct?
Yes, Your Honor.
And what were the results?
So she was positive, Your Honor, but it was for her medication assisted treatment. There was nothing else, no other substances.
All right, so the other reason why I had this case recalled back, because this is actually a tough case, right? And it's a tough case, and when you read it on the surface, you should be going to prison. But then there are other things for me to consider as well. The fact that you have a child and it appears that you have changed your life. And defense, I believe yesterday you said that she was being accepted into felony drug court.
Yes, Judge, and also I had some argument for the court too. The court was ready, but that is correct, Judge. She was screened for felony drug court. They did not accept her because at the time she had not been sentenced. But I verified with felony drug court that should she be placed on probation, they're able to accept her and can squeeze her in next week.
All right, so state.
Yes, Judge.
I understand why the reason you're asking for prison time. I do, and I want you, Ms. Settle, to internalize what I'm saying. What I'm considering is the fact that she has a child. It appears that she has changed. Sometimes it takes people a long time to have a wake-up call. I still don't understand why you keep having children when your life is not where it should be. But usually when people are addicted to drugs, they're not thinking appropriately to begin with. They're not thinking about the future. They're not thinking about how their drug use will impact everyone else. And state on this case, I see that you're asking for a cap of 6 years in the prison. And one case is a second-degree felony. And the other case is a third-degree felony. And I'm assuming she has restitution to pay?
If it isn't included in that plea bargain right there, Judge, then no certain amount.
All right. So we're gonna see the amount of restitution, and state you've had a chance to hear her testimony. Are you still going to be requesting prison time?
Judge, the position of the state is that this offer was made considering the history, the knowledge that Ms. Settle has been before this court previously, also with a new child, asking for the same type of leniency and treatment, and was offered that leniency and treatment and turned it down and returned directly to that life. And so it's not just Ms. Settle the state is concerned about, but it's Ms. Settle's children, it's Ms. Settle's family, and it's Ms. Settle's community, many of which were victims of Ms. Settle. And that is the reason the state is opposed, but the state is cognizant of what appears to be genuine changes in Ms. Settle's life.
All right. And I know that this involves her mother.
Yes, Judge. So the world is an ironic place. It turns out I'm appointed to represent Miss Settle, but I have known Miss Settle since she was about knee high. I've known the complainant, her mother,
And also her brother, who's referenced in the PSI, is someone that I went to high school with, was close friends with.
Mhm.
So I've known this family a long time. I've spoken to the complainant, to her mother, Judge.
Mhm.
She is certainly at wit's end with Miss Settle. She's spent a great deal of money helping her out, trying to get her on her feet. But it is also clear in the PSI that she is seeing and she's witnessed some of the changes that Miss Settle has made in her life and has made. And the question came up yesterday, Judge, what's different or what's changed? And I think the distinction between this time and last time she did not do what she was supposed to do for you, Judge. It's very clear in the PSI back in 2020, she was going for things. She was released from the jail accidentally. She skipped out on GPS. There were all sorts of issues, Judge. In this instance, since both when she was arrested and then certainly after being released on bond, she's made great strides to try and do what she's supposed to do. She's been on GPS, she's been compliant, she's been enrolling programs, she's tried to be a parent to her mother or to her child. She's also shown up here today, Judge. She's not run off, she's not fled, she's not skipping out on things. And when you're talking about therapeutic justice, Judge, when someone's an addict, there's no such thing as a cure. But it seems to me like she's trying to make some legitimate life changes. And I think society and Miss Settle would be served better by trying to get her some therapeutic justice and trying to continue her down this path rather than sending her to prison again. PSI, the complainants themselves don't indicate that they'd like Miss Settle to go to jail, prison. Her mother certainly would like Miss Settle to have the threat of prison or jail time hanging over her head, which is something I think is a great motivator a lot of times. So for those reasons, Judge, we're asking the court to consider probation or community supervision in some form in order into the drug court program.
All right, anything you wish to add, State?
Judge, the state stands by its concern about Ms. Settle being a good probationer, a good candidate for probation. That being said, the emphasis from the complainants was that if this court were to grant supervision, the state would ask for very structured supervision, because I do believe that it is a necessity in Ms. Settle's life at this point. I believe drug court would be appropriate and, if needed, inpatient treatment.
All right. So the court is going to give you a choice. Some people say my probation is very difficult. I'm sure you're aware of that, as I've sentenced you before for not doing what you're supposed to do. I'm going to give you a choice. I can sentence you today, and I will sentence you to 3 years in the prison. Otherwise, the plea negotiation needs to be reworked. And by that, this is what I mean. The case that's a second-degree felony, I will give you deferred adjudication. And if you were revoked, you're looking at 20 years in the prison. Do you understand?
Sure.
And then on the case that's a third-degree felony, I would convict you, but I want the underlying to be 10 years. So you can discuss that with your attorney.
Judge, you'd like the opportunity for probation, Your Honor?
All right, so normally, legally and ethically, I'm not allowed to interfere with negotiations. But what I'm telling you and telling your client on the cap of 6 offer, for me to request that it be an underlying of a cap of 10, that's changing your plea negotiations. And if you want a jury trial on that, you can have a jury trial on that. Do you understand?
Judge, on the second-degree case, is there no application for deferred indicated in that plea bargain agreement?
On that one, let me see. No, it just says that you're all opposed to community supervision in deferred adjudication, but I do have an application for deferred adjudication on that case. And on the firearm case, there is again, there's the state is opposed, but there is an application for deferred on that case.
So the only one we would need to change is the one with the conviction, so the third degree.
Yes.
This court could give them 10 years deferred on a cap of 6. Opposed.
Well, no, on the unlawful, we're off the record, on the unlawful possession, the court wants a conviction on that case.
Okay.
So there will be guilty, but I want her underlying to be the 10 years.
Understood.
And then on the other case at the second degree, I'll give her the deferred adjudication. So the reason why I'm doing that is because then on both cases, you will be subject to the full range of punishment if you were revoked. Do you understand?
Yes.
Understood, Judge.
So if you all want to change that to a cap of 10 and state, I'll still note that you're opposed.
Yes, ma'am.
And Ms. Abrams, on Ms. Settles, defense counsel has told me that felony drug court will accept her. And counsel, is she currently on GPS?
Yes, she is, Judge.
All right, we're going to continue with the GPS. All right, we're back on the record. Is there anything else from either side before the court enters its orders?
Nothing from the state, Judge.
No, just that we have no objection to the change from the cap 6 to the cap 10 here.
All right. Then in cause number 2025 CR 000240, the court is going to grant your application for deferred adjudication. Court is going to sentence you to 10 years deferred adjudication. There's to be regular reporting by Zoom or in person, regular random UAs, proof of employment within 45 days. There's to be no employment as a home health care provider or with minors. This is to run concurrent with 2024 CR 013090. With regards to this, no harmful or injurious contact with KPEC and family. And then there's no contact with Linda Vargas, Destiny Thurston, Juan Uriega.
Uriega, Judge.
Yeah, thank you. I look at Deputy Laura because she's like, I'm trying to teach you. David Getz, Goetz, or Dick Creamer. And there'll be restitution, if any, to all complainants. If there's an issue with the restitution amount, we can have a restitution hearing. And Ms. Ferguson, can you set this in 45 days for restitution hearing, please? In case there is any.
Fair enough.
All right, what date? All right, we're going to come back on September 11th and state that's just to see if there's any restitution amount that's owed. And we'll have a restitution hearing on that day.
Yes, ma'am.
All right, there's to be no contact with Rudy Rodriguez. There's to be 200 hours of community service restitution. I'm going to order parenting classes. Once that's complete, 100 hours will be deemed satisfied. There's $1,000 fine that will be probated. And there's to be a referral to felony drug court. If for some reason she's not accepted in a felony drug court, she's to come back to this court. However, counsel has informed me she has been accepted. And there's to be continued GPS until further notice. Probation, is there anything else with regards to that sentencing?
Yes. Are you waiting?
Yes.
And can you please? No contact, did you say no harmful or injurious?
No harmful or injurious contact with KPEC, PECK, and family. And then there's to be no contact with Linda Vargas, Destiny Thurston, THURSTEN, Juan Uriega, David Getz, GOETZ, and Dick Creamer, and Rudy Rodriguez.
Judge, to put a fly in the ointment, Mr. Rodriguez is actually the child's father.
I'm just going by what's in the plea paperwork. So that's something that will need to be addressed with Judge Glenn. Probation, is there anything else? Anything else with regards to sentencing and that cause number, counsel?
Nothing from the state judge.
Nothing from defense, Your Honor.
All right, I'm showing you what's entitled Trial Court Certification of Defendant's Rights to Appeal. And that cause number, did you review it with your attorney? Did you understand it and sign it?
Yes, Your Honor.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Next, we're moving to cause number 2024 CR 01309. All right, the court is going to sentence you, the court is going to find you guilty. The court is going to sentence you to 10 years in the prison, suspended and probated for 10 years. There's to be regular reporting by Zoom or in person. Regular random UAs. Proof of employment within 45 days. No employment as a home health care provider or with minors. 200 hours of community service restitution. The court will show that 100 hours is satisfied upon the completion of parenting classes. GPS, and I'm sorry, probation will do partial GPS for employment and treatment in each cause number. Waive GPS fees. This is run concurrent with 2025 CR 000240 and referral to felony drug court. And again, if felony drug court for some reason does not accept her, she's to come back to this court. Probation, is there anything else with regards to sentencing?
It's on the other call number as well, field visits.
Oh, thank you so much. Field visits one time per month until further notice.
And can you clarify which count on that call number?
The one I just read, the unlawful possession.
Yes, sir.
They are proceeding on count 1 and they're waiving count 2. Is there anything else with regards to sentencing in that cause number?
No question.
Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and did you sign it?
I did, Your Honor.
All right, because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes, Your Honor.
All right, we can go off the record. Here's the thing. You say you have a new child. Your counsel has told me you have a newborn, that you have finally, the haze has been cleared and you're finally going to do what needs to be done. In each of these cases, in one case, you're looking at 20 years if you're revoked. In the other case, you're looking at 10 years if you're revoked. So from here on out, everything you do, you need to ask yourself 2 questions. Is this something that could potentially result in me being revoked? If the answer is yes, don't do it. If the answer is maybe, don't do it. If there's anything else that's in between, you need to contact your attorney. Do you understand? All right. And if you're not going to do it for yourself, you need to do it for your child. All right. Thank you, counsel. Thank you.
Thank you,
Thank
Judge.
you. It's always great seeing both of you guys.
Me too, Judge.
All right. Thank you. Chase Lopez. All right. Mr. Lopez, today is your plea deadline date.
Yes, Your Honor. I'm covering for Ms. Knowles this morning. When I covered Mr. Jarahan, there's still some discovery outstanding. And they're asking the court to reset the plea deadline one time to allow the state to provide us that discovery.
Okay, what discovery is missing?
It's, Judge, it is actually missing. I looked on Veripic and they don't have the body cams on there, and that's what's missing.
Okay,
And I was unaware, the offer had been extended. I just was unaware until presently that I believe Caitlin Knowles was the main attorney on this. And I was just notified today that she had notified Mr. Solansky that.
all right, so when do you believe you'll have that?
2 weeks to 4 weeks, Judge. I mean, Megan Galloway has just emailed BCSO to obtain that.
All right, Ms. Ferguson. If you'll extend this plea deadline date for 30 days, there'll be no further extensions.
Thank you, Your Honor.
All
Thank
right,
you,
thank
Judge.
you. What date? All right, August 21st. Thank you for addressing appropriately for court. Once you sign the reset form, you're excused, okay? Thank you. Thank you.
Excuse.
Yes. All right, who's here on Adriana Ramos? Hello. All right, have you had a chance to meet with your attorney? All right, and defense?
Yes, Judge, I've met with my client, just assigned today. I need time to go through discovery. So I asked that we receive you a court date.
All right, Ms. Ferguson, on this, do 30 days for discovery and counsel. There's going to be a quick turnaround after the discovery. All right, August 21st, counsel.
That works. Judge.
All right, once you sign the reset form, you're excused. Thank you for dressing appropriately for court.
Thank you, Judge.
You're welcome. David Moses Escobedo. David Moses Escobedo. All right, the bond was reinstated. Why is he still in custody?
It is not showing that it's been reinstated, Judge. I looked online yesterday. I spoke with the bondsman. They said that they had agreed to it. I didn't think
signed
they filed
every-
anything.
Yeah, I've signed everything. It is 2025 CR 02743.
Honestly, didn't show any updates in regards to that.
Okay, because he should have been released. No, the bondsman sent something over. All right, you want to get in touch with the bondsman?
Okay,
All right.
they need to file something.
But they did file something. I remember asking that the bond be restored.
With that.
So if you can have them, Mr. Escobedo, just have a seat. If you can see if they can find it. Yeah. Michelle Battles. If you'll come forward, please. Hello. Hi, your attorney is currently on vacation. Ms. Ferguson, if you'll recall this back for August 26th. All right, so once you sign the reset form, you're excused. You're welcome. Valerie Campion. Hello.
Hi.
Hi, so you were late for court. Here's the thing. You cannot be late for court. You've been here before, you know where the court is located. Other judges, guess what they would have done? Taking you into custody. Once you're late, you're late. You understand?
Yes, ma'am.
Court starts at 9 a.m. All right, state. Has an offer been tendered?
Judge, an offer was tendered on the cases that are indicted currently. She,
Mhm.
as the court can see, she's got a number of pre-file cases. The state checked this morning, there's no labs on those cases, so we would be asking the court to see if they would give us a little bit more time so we can try to encompass all of those cases. But just to answer the court's question, an offer was tendered on these specific cases, yes, but there's no agreement on these specific cases yet.
All right, Ms. Ferguson? On this case, I need a plea deadline date with the jury trial setting. It should be a short trial.
Yes, any of these would be short, Judge.
Okay. All right, your jury trial date and plea deadline date is going to be September 23rd. The court will not consider any plea bargain agreements after that date without good cause. Otherwise, you'll have to plea open to the court. Do you understand? You need to make sure you're on time.
Yes,
All right, once you sign the reset form, you're excused, and thank you for dressing appropriately for court.
thank you.
You're welcome. And Matt, on those cases, if you can get an acknowledgement of discovery from the state, if you could do an acknowledgement of discovery, if that hasn't been previously done on those cases.
Okay.
All right, thank you. Pearl Gonzalez. All right, are you ready?
Yes, Your Honor.
And is she here?
That's my knowledge.
All right. Deputy Laura, if an announcement could be made for Pearl Gonzalez. All right, she has a PR bond, counsel. The court is in receipt of a violation report.
That's my understanding, Judge. And I know that this honorable court set this compliance hearing today. My fear is that you did not get notice of that. I was not able to relay that to her. So we're just requesting that the original date in August be left. In that, I don't know if there's actually notice to be today.
Right, well, so here's the court's issue. With the violation reports, of course, the court doesn't have to set a hearing. But according to the violation report, it states that the defendant failed to report to our office as directed by the court. And then on July 17th, the defendant completed their orientation and left, refusing to provide a UA sample to our office. And they've been seeking to bring her back into compliance, but have been unsuccessful.
That's my understanding, just as of the issuance of that. I don't know if that has changed from now until this point. So if she got back into compliance with them and not been updated. So that's where I'm at, Judge. I just don't know where we're at currently.
Well, if there's no objection from either side, I can email the pretrial services officer and ask if she is in compliance or not.
No objection from the bench.
No objection.
All right, so just give me a moment. Thank you. First things first. Why were you late for court? Court starts at 9 a.m.
I was in court, but I didn't give my name, but I was here.
No, I call the docket at 9. And when people answer the docket, then I check them off as having appeared. But you're scheduled for jury trial today.
That's correct, Judge. We filed a motion for continuance on this.
All right, as soon as I get the file, we'll see about your motion for continuance. All right, the court is calling 2025 CR 002807. State versus Angel Cepedez Rhonda. Could I have parties announced?
Ashley Jones for the state.
John Reitmeyer for the defense.
All right, and are you Angel Rhonda?
Yes,
All right, we have an interpreter. If the interpreter could raise your right hand, do you solemnly swear or affirm you will faithfully translate from English into Spanish and Spanish into English, so help you God?
I do, Your Honor.
All right, you can lower your hand if you'll state your name for the record.
Cesar Chavez, license number 2203.
All right. Defense, you filed a motion for continuance.
We did, Your Honor. In getting ready for trial, we've subpoenaed several records that we haven't been able to receive yet. One of them, we were told the staff is not back from summer vacation. The other one, they have paused our request and sent it to the Attorney General's office for review for open records. We've had issues getting witnesses that could help the defense due to several fears that they may have about coming forward. With that said, we did receive a late disclosure from the state about 404B evidence that I haven't had time to go through. There's also been another late upload to e-discovery that I was able to look at. I have talked with the state. I don't fault them for the late disclosure, but.
Well, no, here's the question, because this has been set for jury trial since May. This has been on the court's docket since April. So what was uploaded late?
It was about the complaining witness in a meeting that they had. There was a name that was mentioned in this interview with her that we have not seen before, who may have information.
And when did this interview with the complaining witness take place?
Your Honor, we met with the complaining witness last Tuesday. It was quite a very long interview with an interpreter with Mr. Caesar here. And that's when we received the information and we uploaded it over the weekend. And
this is what I don't understand, and maybe somebody can help me understand. I don't understand how a case is indicted and then the state is speaking to the complainant, a day before trial or a week before trial, and all of a sudden there's new discovery. I'm like, why is everybody waiting till the last minute to speak to a complainant? All ducks should be aligned and in a row. Maybe I did things differently when I was a prosecutor, but once I had took a case to indictment to a grand jury, I've received all the information, done all the investigative work. And if I met with a witness, I would tell them, this is the day we're going to trial. What you need to do is listen to the questions, answer the questions, and tell the truth. That was the extent of our meeting. I don't understand waiting and then interviewing a witness, then obtaining all this new information, then dropping it on the defense. And we're scheduled for trial. I don't understand.
Or Judge, in addition to my own reasons, I understand the state has a reason for themselves.
Yes, Your Honor, I can speak to that. We do have an officer who is out of town starting tomorrow. As the court may or may not know, there was a translator needed for the investigation that was done. We were able to get a hold of that officer, and he is out of town and starting tomorrow.
All right, so as far as the state not having its witness, the state is not, the court is not going to grant a continuance based upon the state not having their witnesses. That witness, everybody knew this was the jury trial date because everybody was here when we said it. So, and then with the 404B?
Well, it was late notice. I haven't had a chance to go through that. I just saw I just got notice of the filing yesterday.
Well, has the law changed with 404B notice that can be given up until the day of trial? What's in the 404B?
And Your Honor, I can speak to that. It's actually stuff under 3837(1)B, which is just nature of the relationship stuff. It was a couple instances that the complainant described that described the nature of their relationship throughout.
Well, that's not coming in. So what's the next issue? Any 404B that is related to their relationship, that's not coming in.
Then Judge, it would just.
That was just dropped upon you.
It would just be my original, we had subpoenaed records for trial and we don't have them.
When were the records subpoenaed?
Offhand, several weeks ago. I don't have an exact date. I'm talking about.
All right, so I need to know when the date the records were subpoenaed. Your other issue in your motion for continuance is that there are fears of immigration enforcement as it relates to your witness. Don't know what to do about that. There's going to be fears. So I can't grant a motion for continuance based upon a person's fears of coming into court. Now, if somebody wants to agree to have the witnesses by Zoom, you can, but otherwise I'm not giving a motion for continuance because someone is afraid of immigration consequences. Because if that's the case, then we will not be able to have a trial, who knows when. All right, anything else?
Not from the state?
All right, motion for continuance is denied. And state any 404B information that has to do with this defendant's relationship to the client, that's not going to be admitted unless the defense wants it admitted.
We understood, Judge.
All right.
Is there a time you like us to come back?
Yes, I'm going to have the jury's going to be out in the hallway by 11:30. I anticipate us recessing and doing jury selection at 1:30. All right, thank you. David Escobedo. Oh, I'm sorry, counsel. I'm sorry, Mr. Escobedo. Just have a seat. I'm waiting for your attorney to give the court information. This is 1:30. All right, are the parties still here on Pearl Gonzalez?
Yes, ma'am.
All right, so the email the court received from pretrial services that she is not in compliance. And what they sent me, they said, as of this writing, no, ma'am, she has failed to comply with pretrial. The defendant has not responded with us since 7/17 and multiple attempts have been made by her officer.
Thank you for the update, Judge.
Sure, no problem.
I know she's indigent. I believe it's a possibility of her being perhaps living on the streets. She was in custody more than 90 days without an indictment being generated, so that's what the PR bond did issue. I guess if we could be heard on, I guess,
Sure.
they want to be heard on
All right, the court is calling 2025 CR 008155 State versus Pearl Gonzalez. Can I have parties announce?
Jason Garahan for the state, Your Honor.
Renee Munoz on behalf of Ms. Gonzalez.
All right, this hearing was scheduled at 9 a.m. It is now 10:46 a.m. The court received a violation report that the defendant is out of compliance with pretrial services. According to the violation report, they state that she attended orientation and left, refusing to provide a UA sample to our office. For the record, both parties had no objections to the court emailing pretrial services to see if Ms. Gonzalez was back in compliance. And the email the court received is that the defendant is still out of compliance and has not been seen since July 17th, and they made multiple attempts to contact her. Defense, is there anything you wish to put on the record?
Yes, Judge. I know that she is indigent. She's being represented by the Public Defender's Office. And we believe there's a chance she may be homeless and otherwise unable to abide by the current conditions as set. We respectfully request that a summons issue in lieu of a warrant.
All right, state.
State requests judge's warrant, Your Honor.
All right, the court will issue a judge's warrant. Counsel, if your client makes an appearance, the court will reconsider. But for now, the court is issuing the judge's warrant and remanding your client without bond.
I understand. Thank you, Your Honor.
All right, thank you. David Edward Lopez. Is your attorney here?
Yes, Your Honor, I'm right here.
Okay, sure. Yes.
Yes, Your Honor. I've been conferring with the state. I received some CPS records today. I have not yet, but I need to request some records from Cedar Crest. It's an completion place. I probably need a court order to try to get those. I've been talking with the state. I have tendered the complainant's name and her mother's name so the DA can have a chance to speak with them. We're asking for a continuance in this case to put all these things together.
All right, has a motion for continuance been filed?
It hasn't. I thought the state was going to ask for this.
Apologize, Your Honor. Our understanding was that it was not set for trial. It was set for either discovery or a plea deadline hearing.
Yes. So it says today is your final discovery. And you were filing an investigation motion?
I filed a motion for an investigator. He met with my clients. I did receive new discovery today. I picked up the disc. I'd like an opportunity to review it and go over that with my investigator. We have a meeting set with the investigator to see what other documents we might need to either subpoena or ask the court to get a court order for this.
All right, Ms. Ferguson. If I can have a plea deadline date and jury trial date, please. I'm sorry, when?
Number 23rd.
All right, your plea deadline date and jury trial date will be September 23rd.
Thank you, Your Honor.
All right, you're welcome. Once you sign the reset form, you're excused. Thank you for dressing appropriately for court. Thank you. Who is here on Yvonne Ordonez? Court is calling 2025 CR 003633 State versus Yvonne Ordonez. Could I have parties announced?
Megan Galloway for the state.
Renee Munoz on behalf of Ms. Ordonez.
And are you Ms. Ordonez?
Yes.
Counsel, have you received all discovery? Did you review it with your client?
Yes, Your Honor.
Court will find that the state is in compliance with discovery. Probation, there's no application. Ms. Ordonez, did you review the true bill of indictment with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
Yes, Judge.
State, are you proceeding on the indictment as presented?
Yes, Your Honor.
Ms. Ordonez, did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places? You're charged with criminal mischief, $2,500 to $30,000. That's a state jail felony. Range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to a $10,000 fine. If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you, and you will be allowed to withdraw your plea. Did you understand? You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent. Did you understand by entering this plea, you were giving up those rights?
Yes,
Did you intend to give up those rights and enter into a plea in this case?
yes,
Counsel, has your client been able to provide you with any defenses?
She has,
Do you believe she has a rational as well as a factual understanding of the charges against her?
my opinion, she does.
Do you believe she's currently competent and was legally sane at the time of the offense?
That is correct, Judge.
Ms. Ordonez, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea?
no,
Anyone promised you anything other than the plea?
no,
Are you satisfied with the way you've been represented?
yes,
Are you a U.S. citizen?
yes,
Court will find that defendant has knowingly and voluntarily waived her right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it? According to the plea, punishment is to be assessed at 2 days in the Bexar County Jail under 1244. There's an $800 fine and no applications. Did you understand that to be the plea?
yes.
Defense, is that the plea?
Yes, Judge.
State, is that the plea?
It is, Your Honor, and I can speak to the term if you'd like at the appropriate time.
All right, thank you. Did you review the waiver of appeal paragraph with your attorney? Did you understand it?
Yes, sir.
Did you sign it in both places?
Yes,
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
yes,
Counsel, are there any such motions?
No, Your Honor.
Outside the agreement, there is to be no contact with Freda Flores. Did you understand that's a recommendation from the state and the court does not have to follow those recommendations?
yes, sir.
Then to the offenses charged, how do you plead?
Guilty.
State any evidence.
State offer states one in attachment.
No objection, Your Honor.
Did you review the waiver and consent to stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, sir.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes,
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there will be no live testimony. Did you understand?
yes,
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same. All right, after reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. The court will find you guilty. State?
Your Honor, the reason that this agreement was struck or offered by the state and accepted by the defense was because the offense date and for the offense that we're here for is February 13th of 2023. The defendant did have some additional felony charges for which she was indicted for in 2024. However, this case had not been turned into our office yet. And so regarding the 2024 indictment, she did take accountability and enter a plea on those cases. However, this case was still outstanding at the time. In that case, she had 255 days worth of credit in the Bexar County Jail that had this case been filed at the time, she would have received credit for. And so I took that into account and that's why we reached the agreement that we did.
All right.
That's correct, Judge.
All right, the court will follow your agreement, find you guilty, sentence you to $800 time and money to run concurrent. 2 days in the Bexar County Jail on 1244. There's to be no contact with Freda Flores. The court will give you credit for any time served and the court will show that the judgment is satisfied. Did you review the trial court certification of defendant's rights to appeal with your attorney? Did you understand it and sign it?
yes, sir.
Because it's a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes, sir.
All right, we can go off the record. Here's the thing. I understand people get upset with the way people are driving. And it appears from reading the police report, both of you were in the wrong. She was in the wrong for riding your bumper, almost hitting you. She was in the wrong for throwing, some sort of liquid at your vehicle. You were in the wrong and in a dangerous situation from getting out of your vehicle and striking her vehicle. You understand?
Yes, sir.
All of this could have been gone left, farther left so quickly, because if she would have had a gun, she would have ended up shooting you. And then everybody would say, well, was it justified? Was it not justified? Because she came at her vehicle with a weapon. You understand?
Yes, sir.
So what I've discovered is when you're driving, Just have patience. Don't honk at anybody unless it's to say hello. And you know what my mom always told me? Let them pass. She's like, just let them pass. Your job is to get from point A to point B safely. You understand?
Yes.
All right, good luck to you. Have a great day. Vincent Arredondo.
We're here. I'm actually waiting on some documentation to be emailed from my office to the prosecutors. I was gonna ask the court to reinstate a bond. He was in the hospital apparently in the last court setting. But it should be here in a second.
All right, thank you.
Thank you.
Oh, with regards to reinstating bond, you'll need to reach out to the bondsman and see if they have any objection.
Well, not even reinstating it. If you would set a new bond,
Okay.
his family can make it apparent.
Okay, sure.
Thank you.
All right, the court is calling 2025 CR 007548 State versus Jacob Vicuna. Can I have parties announced for the record for the state?
Deputy Life for the state of Texas, Your Honor.
All right, this hearing was scheduled at 9 a.m. It is now 11 a.m. The defendant has not made an appearance. Deputy Laura, did you make an announcement?
Yes, Your Honor, I did. He is not out there.
Defense, have you had any contact with your client?
No.
All right, state, it appears that he is on a PR bond. Any requests?
For a judge's warrant, Your Honor.
All right, the court will issue a judge's warrant, remand your client without bond. If your client makes an appearance, the court will reconsider. Thank you. Thank you, state.
Thank you, Judge.
All right, are you all ready on Ronald Allen?
The state is ready, Your Honor. We're present, Judge, ready.
All right, if parties will come forward. All right, if everyone can please whisper, we're going to go on the record. Court is calling 2025 CR 007563 State versus Ronald Allen. Could I have parties announced for the record, please?
Duffy Pitlock for the state of Texas, Your Honor.
Charles Butcher for the accused.
All right, and are you Mr. Allen?
Yes, I am.
We were here yesterday. The court heard evidence on defense's motions. The court ordered or requested that both parties be present today to make their arguments. And so defense, it is your motion. So, and both parties agreed for the hearing that they would combine the motion to suppress and the motion to dismiss. The court requested if both parties would agree to combine the motion to dismiss and the motion to suppress due to objections that both parties were having to particular evidence. And some of the objections with regards to the motion to suppress were not appropriate for a motion to suppress, but they were appropriate in the motion to dismiss. So that is why both parties agreed to combine the two motions. So with regards to the motion to suppress, what I would like to start with is we'll start with number 2, where the defense's argument is there's no probable cause. You may address that, counsel.
Judge, regarding we did hear testimony from Mr. Allen, Officer Che, and Attorney Ireland. We heard Attorney Ireland's recording. We'd seen the state's theory take its full shape. The reason we think that this lacks there's a lack of criminal conduct on this matter, because from the outset, the prosecution relied on a paraphrase quote allegedly said by Mr. Allen, which was, "If I don't get custody, I will make history and there will be dead bodies everywhere." But when we heard the recording, that phrase was never heard by the court in the recording submitted by Mr. Ireland and played for the court. The actual statement made by Ronald was, quote, "So if I was going to do that and I knew all this stuff was going to happen, period, I'm prepared for Wednesday. But something is going to happen that's going to change history, whether you bust these guys or there's dead bodies everywhere, bro." Later, he says, because if they don't get busted, there's going to be dead bodies everywhere. Now, our contention is that neither of these statements includes an assertion of personal action on the part of Mr. Allen. There is no named victim. There is no identified target. And there is no expressed intent to carry out any kind of violence. It's also troubling that the DA's office or Detective Che did not fully review the audio, but simply adopted Mr. Ireland's paraphrase as fact. I think that this misstep undermines the reliability of the charging process and bolsters the necessity for judicial correction through either suppression or the dismissal.
All right, and with regards to no complainant being identified, is there really a need for a complainant to be identified if there's a threat? And I'm not saying it's a threat. These are just questions that I have, Mr. Allen. Is there a need to identify a singular person if there's an alleged threat that there will be bodies?
Well, I think a part of this is the nature of the charge is that this is a terroristic threat on a public servant. Although other public servants are discussed in the 12-minute recording that we heard, none of those public servants are specifically targeted in any of the statements that Mr. Allen made. They're talking generally about a number of things related to the legal strategy, related to the tactics that are being used. And basically, my client is speaking freely to his own lawyer.
All right, but I'm reading the indictment. Is there any objection to the court reviewing the indictment?
None from the state, Your Honor.
None here.
All right, so I'm reading the indictment, and the indictment reads that on or about April 21st, your client did threaten to commit an offense involving violence to a person, namely, and then it says to kill people with intent to place the public or a substantial group of the public in fear of serious bodily injury. So according to the indictment, it's saying a group of people and not necessarily a person who's a public servant.
Of course, Judge. We do recognize that that's what the indictment says. We accept that that's the indictment generally, but we do have issue with the idea that this statement has been taken out of context. He's not particularly naming that he's going to do anything to the court or to the courthouse or to any of the people that work here. I'm also, I think you should know, I've been practicing 15 years and I work in this courthouse every day. And I don't feel like Mr. Allen is a threat to this court either. Further, when we talk about this, Mr. Allen's testimony reflects a constitutional innocence to him because he testified that he believed he was speaking confidentially with his own lawyer. He had no intent to harm anyone. He was not emotionally stable at that point because of the difficulty that he was having with his custody matter. So he was also shocked to learn that the words that he mentioned in his own lawyer, where he has an expectation of privacy, were being recorded and being used against him to third parties.
All right, so do both parties stipulate that a client's conversation with his attorney in a legal capacity is confidential, that that's the bar? Do both parties stipulate to that?
The state understands that confidentiality bar is there with exceptions.
Yes. All right, so do both parties stipulate?
The state stipulates.
All right, so then the next question I have of both parties, is there an exception? And I think both parties know the answer to the confidentiality if there is a threat of violence or if there is a threat of a future crime.
Yes, the state is aware.
All right, and defense, do you stipulate to that?
Yes, Judge, we do know that there are rules, Rule 105C7 of the ethics rule provide for permissive disclosure to prevent criminal acts. And we anticipate that Ireland would be arguing that he had discretion under this section if he reasonably believed the disclosure was necessary to prevent a future crime. However, according to those rules, the comments inside of those rules, comment 13 to 14 in the rules that are promulgated by the state, the magnitude, proximity, and likelihood of harm must be weighed. The threat must appear imminent and grave, and the disclosure must be no greater than necessary. The problem here is that Ireland disclosed everything and voluntarily handed over a recording and that recording was not narrowly tailored as a warning. And then we have his own testimony where Mr. Ireland gets on the stand and he tells us, also in the recording, "I'm not afraid of anything regarding this case." That contradicts a reasonable belief of a grave and imminent harm.
But counsel, wasn't his saying he's not afraid of anything about the case in reference to the pending civil case, not the alleged actions that we're here for today? I thought that's what he testified to.
Well, and I do know that, what we're really talking about is that the lawyer that testified, that was this man's lawyer, he continues to try to expand and express that he's in deeper fear than he was in the moment. And I think that's a vital distinction, because if there's a terroristic threat, I think that his action should be immediate. But rather, what Mr. Ireland did, he didn't immediately call 911. He immediately called the amicus attorney. He thinks he doesn't remember that, but we believe that he called the amicus attorney because we got a bill for that. And then further, he calls the Texas Bar Hotline, which is going to favor him making this disclosure, at least to mitigate the immediate harm. But I think on retrospect, after 100 days in jail, the harm and the potential harm has been mitigated.
All right, so let's start here. The first thing is that the court finds through stipulation, and I think both parties know, that when someone is speaking to their attorney about legal matters that they've been contracted to do, that normally it's privileged. But I think both parties have also stipulated that there are exceptions to that privilege. And one of them is if there is a threat of future criminal activity, or if there's a threat of harm to anyone else. So let's start. State, do you want to address whether or not the communication that was testified, that is the basis for this alleged offense, whether or not that was privileged?
Yes, Your Honor, that was not privileged communication. It is detailed in the exception for furtherance of criminal activity, express or implied intent by saying if X does not happen, then Y is going to happen. If X, I don't get my custody, then Y, there's going to be dead bodies everywhere. That is both express and implied. Express, dead bodies, implied, maybe the how. But this was not privileged communications between an attorney and a client. And no, the shift of the communication that you heard, the audio recording, that statement comes at like minute 10:45. I'm prepared for Wednesday, but something is going to happen that is going to change history. You bust these guys or there's dead bodies everywhere, bro. So to say that the attorney, Mr. Ireland, wasn't scared, that was at minute 4. And Your Honor was correct in assessing that that was not related to the future threat that was going to come 10 minutes later, 6 minutes later. That is not privileged communication. Those privileges are to ensure fair trial, trust between parties. The privilege is not intended to grant people a right to threaten and to use words to cause a reaction like what happened in this case. It's not privileged.
All right, so the court is going to find that there has not been a violation of the attorney-client privilege under the disciplinary code 1.05C7. The court is finding that the recording is not illegal, as Texas is a one-party consent state, and the attorney knew that he was recording and he was a part of the communication. There was no third party in the room. It was Mr. Allen and his attorney. Now, with regards to the warrant requirement, both parties stipulated that this was that the defendant was arrested under warrant. So there's a warrant requirement that has been met with regards to that. Now, the next thing I want to talk to you all about is whether or not the communication to his attorney that we're here for, whether or not that's protected speech. And that's a part of your motion as well, client, Mr. Butcher.
Yes, Judge, that goes towards the motion to dismiss regarding this. I think there's some particulars in the recording and in what was discussed with Mr. Ireland on the stand. There are a number of statements that Mr. Ireland stated that tend to show that at the moment, Michael Ireland was not afraid. His own words and conduct tend to prove it. First off, Mr. Ireland said, you can fire me if you want. If you think I'm not doing my job, then go ahead. I think the implication from that is that Mr. Ireland had a calm and professional demeanor and he was not in fear. Further, Mr. Ireland said, you're getting F. In that regard, he's aligning himself with the client emotionally and tactically. And I think that matters because he's continuing to engage in this as not somebody that's looking for a criminal intent, but he's looking for a way to align himself with his client and think about the custody case strategically and tactically. He even says, I agree with you when Mr. Allen indicates that he is concerned and afraid because of some coincidences that were happening in that litigation. Further, they even talk about subpoenaing a gentleman named Sherwood. So Mr. Ireland is strategically engaging regarding the subpoenas that he's going to issue and the work that he's going to do in furtherance of that custody case. Now, I realize that this court isn't about reviewing a custody case in any way, but what we think is that Ronald Allen's testimony reflects constitutional innocence because Mr. Allen testified that he believed he was speaking confidentially with his lawyer. He had no intent to harm anyone. He was emotionally distraught, particularly due to the custody losses, and he was shocked to learn that his words had been recorded. When we get further into this, Ronald also expresses his own fear in the recording because he says, I'm scared for my life, dude. That's not the speech of a would-be assailant. It's the language of a man trying to make sense of what he perceives as an unjust legal system. In my motion, I mentioned a number of cases that are constitutional cases, and one of them is the Watts case. In the Watts case, in a 1966 anti-draft rally in Washington, D.C., an 18-year-old draft dodger made the following remark, quote, if they ever make me carry a rifle, the first man I want to get in my sights is Lyndon Baines Johnson, LBJ. This, by the Supreme Court, was interpreted as a threat. This was interpreted as a threat by the authorities under the United States Code regarding terrorist threats toward the president. But the Supreme Court found in 1966 that they reversed the conviction, holding that Watts' statement was political rhetoric and not a true threat, and therefore was protected speech under the First Amendment. Now, this applies because the context matters. True threats are not protected speech, but the government must prove that the speaker intended the statement to be understood as a serious expression of intent to inflict harm. So hyperbole, exaggeration, or emotional venting, even if it's crude or alarming, doesn't qualify as a true threat. Lower courts later differed on the objective versus subjective standard on this, but Watts did emphasize the importance of both context and intent. In reference to Ronald's case, this also was a vague and conditional statement. It was delivered in a nonviolent setting, and it was interpreted literally by the government, despite clear indications that it was a figurative rhetoric that Mr. Allen was engaged in. Similarly, this case, in Ronald's case, it was emotionally charged, but it was conditional, and it was made during a private dispute involving custody. Now, Texas courts regularly apply the Watts principles. There's another case called Lopez v. State, where 631 Southwest 3D 107. In that case, the court explicitly cites the Watts case in evaluating whether a defendant's statements were true threats or protected speech. And in that case, it was held that the defendant's statements about bombing a school were not protected speech because they were specifically targeted and intended to be taken seriously. But the key takeaway on that is that Texas courts always adopt the contextual approach from Watts, looking at the surrounding circumstances, the intent, and the audience. In this case, those factors are highly in favor of a dismissal for my client. Further, there's another case called State v. Hansen, where the courts recognize that political hyperbole, even if it's violent in tone, may be protected under Watts. There's also the Dorset v. State case, where a defendant told officers, y'all better wear your vest because I'm gonna start shooting. This was held as a true threat, but only because of the content, including a history of violence and the ongoing criminal conduct resulting in the officers responding in that case. Watts influences Texas law even without being codified. Texas courts do adopt some options of Watts because they talk about a true threat test as a conditional limitation in applying the criminal code 22.07. The judges are to act as gatekeepers even if the conduct appears to violate the literal text of the statute, but it must pass the Watts standard in these matters. There's another case, more recent in 2015, the Alanis v. United States case, where Judge the Supreme Court held that punishing threats require proof of a mens rea or a subjective intent to threaten. The person cannot be convicted. The Alanis case holds that a person cannot be convicted based on how others might perceive their words. Rather, the speaker must actually intend for those words to instill fear or communicate a threat. In this case, the full transcript demonstrates Ronald's alleged threat was embedded in an extended stream of anxious, erratic speculation and emotionally charged grievances, where at one point Ronald even says, I got called into jury duty the same week in the same courtroom. The odds of that is like me winning the lottery 20 times in a row. Bro, it didn't even happen. He further elaborates, hey, I had jury duty, dude. They asked me certain questions and they made me sit there all day. The same effing judge. They wanted to know what I knew and if I recognized those other two girls. When I read these statements, they don't seem to be statements of intent. They're statements of subjective fear, suspicion, and confusion. And it's exactly the kind of talk one might share only with their lawyer while trying to process whether the system is fair or rigged. So here, far from planning any violence, Ronald was exploring whether something conspiratorial was happening to him, and he was seeking his lawyer's validation and advice. In the same way in Alanis, the court emphasized that convictions under federal threat statutes require subjective intent. So the speaker must actually have intended the words to be understood as threatening. In that case, the court reversed a conviction that was based on an objective, reasonable person standard and holding that omitting a reference to intent in a criminal statute does not mean that the mere negligence is the appropriate mental state. So here, we might agree that the words that Ronald used in his lawyer's office were negligent because they might be interpreted as a threat, but his intention, and the state hasn't shown that his intention was to make a threat to the general public.
At this juncture, isn't whatever your client's intent, that's something for a jury to decide, or if this were a bench trial, then it would be for me to decide. But is that correct? That's something for the jury to decide what his intentions were. At this point, based upon your motions, what you're here for is whether or not there was a warrant issued. It's been submitted that there was a warrant issued. Both parties stipulated to that. Whether or not the communication with his attorney was privileged or not. I'm finding that the communication was not privileged because it falls under the exception of a threat that was being made. So the threat that was being made, that wasn't privileged communication. It falls underneath the exception. Now, whether or not Mr. Allen, whether or not you meant that, or whether or not it was intentionally, knowingly, or whatever the mens rea may be, that's something for a jury to make that determination. At this point, this court, I'm just making rulings upon motions that are presented to me. But there are some things that I legally am not allowed to make rulings on. One of them is determining what your mens rea is, whether it was intentionally, knowingly, recklessly, whatever it may be. And that would be what is actually in the indictment. So in the indictment, they're stating that you made a threat with the intent to place the public or a substantial group of the public in fear of serious bodily injury. So at this point, for this hearing, it is not within my jurisdiction or purview to determine whether or not you made a threat with the intent to do whatever, right? That would be something that a jury would decide. Now, if you were having a bench trial, then I would be in the place of the jury, and then I would listen to evidence and make a determination of whether or not I believe beyond a reasonable doubt that the state has met its burden based upon what's in the indictment. You understand?
Yes, ma'am.
So what I can tell both parties is that, one, there was a warrant. Both parties stipulated that a warrant was issued. Number two, the court is finding that while your communication with the attorney is confidential and private, right? But the exception to that, one of the exceptions, if there's a threat that's being made. So the communication, the court is finding the communication that you had with your attorney, the court is finding that that falls under the exception of attorney-client privilege. So, State, you want to address the defense's other points, please?
Yes, Your Honor, we would start with point number 5 in the motion to suppress, that the statement was not a true threat. The state is offering to the court and to defense what is Garcia versus State, 583 Southwest 3D 170.
Thank you.
All right, and I'm aware of the case, but I'll review it. Thank you.
I have flagged a couple important spots. The First Amendment does not protect speech like this. A true threat, and Your Honor, you will find this, I believe, on page 2, that first flagged one. True threats encompass those statements by which the speaker communicates an intent to commit an act of unlawful violence to a particular individual or group of individuals, regardless of whether the speaker actually intends to carry out the threat. And this Garcia case quotes a Supreme Court case, Black 538 US, and that's at 359. The reason that the First Amendment does not protect violent speech like this is to promote public safety and curb misdirection of resources. When defense brought up Watts, that is specific to the draft. And the gentleman in that case didn't know if he was or was not going to be drafted. So it was hypothetical, hyperbolic. In this case before the court, we heard the recording on Wednesday, 3 times, Wednesday, Wednesday, Wednesday. When the defendant talks about dead bodies everywhere happening on Wednesday, I'm gonna make history. This is not hypothetical. This is distinguishable from Watts. The defendant here is making direct threats. Now, this language is not ambiguous or exaggerated. If X, then Y. When defense says, well, look at the attorney, Mr. Ireland, he did not express fear. He did not interrupt or disengage. In the 12-minute conversation, it was 1 minute and 25 seconds after being threatened by the defendant that his attorney, his own attorney, says, get out of my office. Subsequent to that, this attorney paid for active shooter training for everyone at his office, paid for them to become familiar with guns, concealed carry, locked the doors to his office. The defendant scared this man, and that is the state's argument. This is not protected speech. It was intended to make a response. It does not matter if he intended to carry it out. The intent is to place the public in fear. It was directed to a specific date. We entered that Wednesday court date in the civil courthouse. It was, it was not a joke. It was not to be taken lightly. On that same case before the court, if we may go to page 3, defense spoke of lack of mens rea. Paranoia is not a criminal element. This conversation was more than exploring conspiracies against the defendant. This was not a private emotional procession or communication with the attorney. This is more than delusional, exaggerated, and distressed. It was a terroristic threat. He was not seeking knowledge. He wanted a reaction. Was it to light a fire? Who knows? But the fear was more than just at the office. It is at the courtroom. It involved the families involved in the civil proceeding. This type of language is not protected under the First Amendment. It is a true threat, and therefore defense's point number 5 should be denied as well.
All right, this is what the court is going to do. The motion to dismiss is denied. The motion to suppress is denied. I'm going to schedule this for a jury trial for September 30th. And so if there are more motions for the court to hear, please bring your motions before that date. Ms. Ferguson will make sure that it is placed on the docket.
Judge, is there any possibility that I can re-urge my motion to reduce bond
Yes.
at this time?
Well,
And
not
I'd
at
like
the-
to ask for that because
Well, not at this time, but if the state has no objection, we can do it later in the week.
The state would object.
All right. So you'll have to give them their 10-day notice. Or I'm sorry, state, how much time do you need? You need less than 10 days?
For the reduction?
Yes.
We would.
All right. So if you all will confer on a date with Ms. Ferguson.
Yes, Judge.
All right. And then we'll go from there, okay?
Okay.
All right. They may be able to do it sooner. Amanda Ellis? Yes.
For a reset.
All right. Where are you on discovery?
Obviously, the discovery, we got an offer today, the one to think about the offer.
I'm sorry. I'm sorry. You said you had an offer?
Yes, today, and we to think
Okay. All right. How old are you, Miss?
37.
All right, Ms. Ferguson, if you set this in 2 weeks for a plea deadline date, please. And it's Amanda Ellis. All right, August 14th, and you need to make sure you're on time for court. The next time a warrant will be issued. Do you understand?
Yes.
Unless there's good cause. All right, thank you. Once you sign the reset form, you're excused. Fernando Guzman?
I'm here for him, Judge.
Yes. All right, counsel, where are we on discovery?
I believe I have all this everything.
And was an offer tendered?
Yes, Judge.
All right, sir, how old are you?
45.
All right, Ms. Ferguson, I need a 2-week reset on Guzman for a plea deadline date. All right, it'll be for August 14th. What page is he on? All right, thank you. All right, Mr. Guzman, you need to be on time for court next time. Otherwise, a warrant will be issued unless there's a good cause for your being tardy. Do you understand? All right, and if you're drug tested today, what are the results going to be?
I've been taking medication for my surgery. He had bladder surgery, Judge, and that might be part of why he's late.
Okay.
And part of why we need a reset, just get him a little more comfortable from the surgery.
Okay.
And we expect that we might likely take that plea bargain.
All right, once you sign the reset form, you'll be excused, okay? Thank you. Moses Ross,
Present ready, Judge.
are you ready to proceed on the motion?
No, Judge, it's just a bond setting.
Ah,
The one is what?
good morning. All right, is this,
It's family violence, but MTR, but the new number ones are criminal trial judge.
all
I
right,
believe that's, well, Family violence, give it to us since it has a new number one.
All right, the court is calling 2023 CR 3543 State versus Moses Ross. Can I have parties announced?
Jason Garahan for the state, Your Honor.
Nick Aguilar for Moses Ross.
And are you Mr. Ross?
Yes, ma'am.
All right, you are here on a motion to revoke. It's a deferred adjudication, so you're entitled to a bond. Have both parties had a chance to confer on a bond amount?
Yes, Your Honor.
And have parties reached an agreement as to a bond amount?
Yes, Your Honor.
And what would that be?
On each of the cases, Your Honor, a $15,000 bond.
All right, he has two cases.
Yes, Your Honor.
All right, and what are you requesting on each case?
On each case, $15,000, Your Honor.
All right, then the court is also causing 2024 CR 4456. All right, the court is aware of the defendant's history because he's on probation out of this court. So in each cause number, the court will set his bond at $15,000. There's going to be partial GPS, waive fees, and there's to be no contact with the complainant in each cause number. All right, Ms. Ferguson, I need a contested hearing on Mr. Ross. All right, so we're going to come back on August 18th for a contested hearing in each cause number. All right, thank you.
He would like to address you about the partial GPS.
I'm a full-time dad. I work all the time. And the reason why I'm in trouble right now is because, can I say that? I got caught with the.
So here's the thing. I don't think you want to speak to the allegations that are in the motion. So I'm telling you, partial GPS for employment. Thank you. All right, Vincent Arredondo. All right, so on this case, you're saying he was in the hospital, correct?
Judge, I'm gonna, and the prosecutor's already taken a look at it. There's some emails that our client was sending that morning of court, I believe it was 18/24. And then there's also a document from Central Med where they said that dated that same day that he was under their care. He'd gotten a spider bite and was in tremendous pain. Your Honor, you were not here that day. It was Judge Angelini and Megan Enriquez, my associate, had asked him.
All right, everyone, please whisper.
If we could try to get the client in at a later date, later in the week or something, and that was denied. So what we're asking for is that you just set him a new bond. She's been in custody for about a month.
All right, and with regard, do you all have an agreement on the bond?
No.
No, we do not.
All right, court is calling 2024 CR 012424. And does he have a bond on the 2025 number or no?
Do you have a bond on your other case still, or is it just the remand on the one case?
I think it's on both of them.
Let me, just one moment, Cindy, off the record. Let me see if I can find if he has a bond in that.
Sorry about that, Judge.
No problem. All right, on this one, it shows that a bond was closed on this one as well. Yes, so they did an affidavit to surrender surety on this one as well.
Oh, okay.
So on the 2025, it's the affidavit to surrender surety. And let me see if the other one is also an affidavit to surrender surety. All right, it says on here that on January 2nd, 2024, received a bond. Okay. Notice, setting. On this one, it shows a bond forfeiture. And then there's already a NICI. So that's on the 2024 case. All right. Now we know where we are. So on the 2025 case, that was a affidavit to surrender surety. And on the 2024 case, that was a bond forfeiture. All right, court is calling 2024 CR 012424 and 2025 CR 007553. State versus Vincent Arredondo. Can I have parties announced for the record?
Jason Garahan for the state, Your Honor.
John Koontz from Mr. Arredondo. I'm here for Megan Enriquez.
All right, and are you Mr. Arredondo?
Yes, ma'am.
Do you have any objection to Mr. Koontz standing in?
No, ma'am.
All right, so you're here requesting a bond, is that correct?
That's correct, Your Honor.
All right, state, in each cause number, is there a bond amount that you are requesting?
The state would be requesting a $20,000 bond in each case.
20,000?
20,000, yes, Your Honor.
And defense, what are you requesting?
Your Honor, I request a $2,500 bond on each. These are state jail level offenses. We understand that one has been indicted as a repeater. And when you look at my client's criminal history, it's for the most part very low level offenses. There are no shootings or anything like that that I saw. And, so
Any
we were-
violent history?
Not particularly, Your Honor. However, he was in court in March of this year. And then this new case was, his arrest is in April of this year. So that's one of the positions of the state. Previous bond on each case was set at $10,000.
All right. Is there anything else?
No, Your Honor. Thank you.
All right, so Mr. Arredondo, can you raise your right hand for me, please? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, ma'am.
All right, you can lower your hand, state your name for the record.
My name is Vincent Garza Arredondo.
All right, I'm gonna set a bond amount for you, but in order for me to set specific conditions for you, I need to ask you some questions. So it's not about the case, so please do not talk to me about what you believe the facts are in the case. Do you understand?
Yes, ma'am.
All right, so have you ever used any type of drugs in the past?
In the past, yes, ma'am.
And what would that be?
Mainly marijuana and methamphetamine.
Have you ever in the past been diagnosed with any type of mental health issue?
Depression.
And have you ever received any medication for that?
I'm here in county, yes, they gave me medicine. I'm receiving medicine.
And if you were released on bond, do you have a place to live?
Yes, ma'am.
And is that by yourself or is that with someone else?
This is my dad.
Are there any minors in the home?
No, it's just my dad and his dog.
So there are minors in the. Okay. All right. Is there anything else from either side?
Not from the state.
Nothing, Judge. Thank you.
All right. So in cause number 2025 CR 00553. And I'm sorry, what was the previous bond on these?
10,000.
10,000. All right, and 2025 CR 007553. The court is going to note that the court received information that you were previously in the hospital, and that was the reason for your missing your court date
Yes,
with
ma'am.
the presiding judge at that time. The court is going to set your bond amount at 10,000. The court is going to order a referral to Center for Healthcare Services.
Thank you.
And there's to be 60 sober support meetings in 60 days. And in cause number 2024 CR 012424, the court is going to set your bond at $12,000. There's going to be a referral to Center for Healthcare Services. There's going to be 60 sober meetings in 60 days. And state, in these cases, were you able to tender an offer?
We did talk about an offer and tender an offer, Your Honor. It was today only, so it will be reevaluated later.
All right. So,
And I did explain that to my client, he understands.
And we did give acknowledgement of discovery.
Yes.
All right.
I signed that earlier.
all right, Ms. Ferguson, set this for next week for a plea deadline date. And then after that, if there's no agreement that is reached, you're going to have a jury trial. It's going to be a quick turnaround. You understand?
Yes, ma'am. Thank you.
You're welcome. What date? August 5th?
Yeah.
All right, August 5th will be your plea deadline date.
Judge, would it also be possible to get him sort of pre-screened for the drug court program?
Yes. You'll need to speak to them about that.
Okay, I'll talk to Judge Glenn and see if we can get that set.
All right. And Norma, there'll be a referral to felony drug court. Just let them know it needs to be a quick turnaround.
Yes, ma'am. I'll reach out to them today.
All right, thank you. Who's here on Dalen Newman?
Ready, Your Honor.
All right, and are you all ready to proceed with the motion to revoke?
There.
Court is calling 2024 CR 012811. State versus Dalen Newman. Can I have parties announced?
Megan Galloway for the state.
Peter Calderola for Mr. Newman, Your Honor.
And are you Mr. Newman?
Yes, Your Honor.
Thank you. Did you review the motion to enter adjudication of guilt and revoke community supervision with your attorney? Did you understand it?
Yes, Your Honor.
Are you the same Dalen Newman who was placed on deferred adjudication in 2024 CR 012811 for the offense of theft of a firearm on February 4th, 2025 for a period of 3 years? Is that you?
Yes, Your Honor.
All right, state, you may proceed.
Judge, really quick, there were two,
There are two.
yes, so there's the one, the theft firearm, and then there's cause number ending in 001217W. That's a family violence.
All right. And then we're also proceeding then on 2025 CR 001217W.
Okay, and
just one moment. And that cause number, did you review the motion to enter adjudication of guilt and revoke community supervision with your attorney?
Yes, Your Honor.
And did you understand it?
Yes, Your Honor.
Are you the same Dalen Newman who was placed on deferred adjudication in 2025 CR 001217W for the offense of assault, bodily injury, family household on February 4th, 2025 for a period of 1 year? Is that you?
Yes, Your Honor.
All right, state, you may proceed.
we will be proceeding on the same violation in each clause number, and that's violation of condition number 4. In Bexar County, Texas, the defendant Dalen Newman did then and there fail to report to the supervision officer as directed for the months of March, April, and May of 2025 in violation of condition number 4.
How do you plead to that? True or not true?
True, Your Honor.
State, do you waive the other?
The remaining.
No objection, Your Honor.
All right, in cause number 2025 CR 001217W. Did you understand by pleading true to violation of condition number 4, the court could find it true, grant the motion, sentence you up to 1 year in the Bexar County Jail and up to a $4,000 fine?
Yes.
Knowing that, do you still wish to plead true to violation of condition number 4? Court will find violation of condition number 4 true. And in cause number 2024 CR 012811, did you understand by pleading true to violation of condition number 4, the court could find it true, grant the motion and sentence you up to 2 years in the state jail facility and up to a $10,000 fine?
Yes, Your Honor.
Knowing that, do you still wish to plead true to violation of condition number 4?
Be true.
Yes, court will find violation of condition number 4 true. Is there a proposed agreement?
There is, Your Honor, and just so the court is aware, this is the defendant's first MTR, and he was placed on deferred adjudication in each cause on February 4th of 2025. And so the agreement for the court's consideration is to deny the state's motion, continue the defendant, but alter and amend his conditions to include a TAP evaluation to be done in custody, weekly reporting for 60 days upon release, the moral recognition therapy course, and a 30-day jail sanction to run concurrent with the days that he's in custody awaiting the TAP evaluation.
All right.
That was our understanding, Your Honor.
All right, do you want to raise your right hand for me, please? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, Your Honor.
All right, you can lower your hand, state your name for the record.
Dalen Newman.
Why are you not recording?
I was going down the wrong path. I was kicked out and I was homeless and I couldn't
Kicked
have
out from where?
my household.
And who's in that household?
My mom, my little brother, and my stepfather,
So why did they want you out?
because I wasn't able to find a job in the time that I needed to.
Why were you not looking for a job?
I was looking, but I wasn't applied to or recognized in the time that I was needing to be recognized for work.
All right, so here's the thing, and you correct me if I'm wrong. Usually parents love their children, and if they're doing everything they can to find employment, normally they won't kick them out of the home. So what else was going on in the home?
There was nothing else going on in the home, Your Honor.
So you're telling me if your parents were to testify, they're going to say, we just put him out because he didn't obtain employment, that he was doing his best. He was going out every day trying to find employment, but he just couldn't do it. So we kicked him out because no one would hire him. You're telling me that's what your parents are going to say?
Yes, Your Honor.
All right. Then let's have the parents testify to tell me what was going on in the household. I want to know. Because I find it very strange that parents would put somebody out a child who's doing the best they can, going out, seeking employment, and then they will put them out because they're unable to find employment. So,
Yeah, I do not believe that his parents are present today to testify to that.
oh, I mean, we can always recall this back. We can recall this back for Thursday. And if there's no objection, his parents can appear by Zoom.
Yeah, I believe that Mr. Newman has relayed to me, I believe that his parents are going to allow him back into the home.
Oh, no. I want to know why they put him out of the home. Because if you have parents who put a child out of the home who is doing his best, seeking employment, and I find it just strange that that's the only reason why they would put him out. So I want to know if that's the only reason why they put him out.
Understood, Your Honor.
And they'll be placed under oath if they appear. And then the court will hear that. So we can recall it for Thursday for your parents to appear. So that they can tell me under oath why they put you out of the home.
May I have a brief sidebar with my client, Judge?
Sure.
Before we proceed.
All right, who's the attorney for Jeremy Lopez and Isidro Garcia?
Mr. Jeremy Lopez.
All right, and counsel? Yes.
After conferring with my client, Judge, he expressed to me that part of the reasons that he was not allowed in the home anymore.
Well, I mean, I want to hear from him.
Okay.
Because he's told me the only reason why his parents put him out of the home is because he was looking for employment and he couldn't find employment. I just find that hard to believe that a parent would do that if somebody is doing what they're supposed to be.
Mr. Newman, do you want to explain to the court what you just expressed to me?
Yes, sir. I said that I wasn't meeting their obligation as in finding a job in time, as I failed to meet y'all's obligation in the 30 days.
What else did you tell me about probation?
Probation, that they said that I was failing to attempt to pursue my probation as in checking in.
Well, no, I mean, you're still saying the same thing. You're adding, but you're still saying the same thing. You're saying that the only reason your parents kicked you out of your home with them is because you could not find employment. That's what you're telling me. That's what I'm hearing. If I'm hearing something different, let me know.
You're not.
All right, so you can have the parents here by Zoom and the reason why I'm doing this is because maybe that's not the right placement for you to be at home with his parents if they're putting him out because he can't find employment and he's doing everything else perfectly. So they can appear by Zoom.
All right, Judge, I just do not have any contact information for his parents.
Oh.
I will talk to Mr. Newman.
All right.
See if I can get them available. However, I do understand as well that in the court summary, it did state that the parents were, I don't know if they were available to be contacted.
Okay. All right. Well, he should have their contact information to see if he's been living with them. All right.
Right, Judge.
All right, thank you. Lopez? If you come down, court is calling 2025 CR 007-014, State versus Jeremy Tyler Lopez. Can I have parties announced?
Megan Galloway for the state.
Danielle Cranberg for the defense.
And are you Mr. Lopez?
Yes, ma'am.
Counsel, have you received all discovery? Did you review it with your client?
Yes, Your Honor.
Court will find that state is in compliance with discovery. Mr. Lopez, did you review the true bill of indictment with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
I do, Your Honor.
State, are you proceeding on the indictment as presented?
Yes, Your Honor.
Mr. Lopez, did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
Did you understand you're charged with burglary of a building, that the state jail felony range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to a $10,000 fine? If you have a plea bargain agreement with the state, the court does not have to follow your agreement. If for any reason the court does not follow your agreement and gives you more than you bargained for, the fact that you enter agreement will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses. The state would call in the right to remain silent. By entering this plea, you're giving up those rights. Did you intend to give up those rights and enter into a plea in this case?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses?
Yes, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
I do, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
I do, Judge.
Mr. Lopez, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Anyone promised you anything other than the plea?
Mm, um,
So anyway, you have a plea bargain agreement with the state. Do you understand that?
yes, ma'am.
Outside of that agreement that you've reached with the state, has anyone promised you anything else?
No, ma'am.
All right. Are you satisfied with the way you've been represented?
Yes, ma'am.
Are you a US citizen?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, ma'am.
According to the plea, punishment is to be assessed at 198 days in the Bexar County Jail under 1244. There's $1,000 fine and no applications. Did you understand that to be the plea?
Yes, ma'am.
Defense?
Yes, Judge, I believe the intention for the state was for it to be a judgment.
All right, state, is that the plea?
Yes, it is, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes, ma'am.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, are there any such motions? Outside the agreement, the state is requesting no contact with city, community, church. Did you understand that's a recommendation from the state and the court does not have to follow that recommendation?
Yes, ma'am.
Then to the offenses charge, how do you plead? Guilty, not guilty, or no contest? Guilty, not guilty, or no contest?
Guilty.
We had discussed no contest.
No contest.
All right, do you understand what a no contest plea means?
Yes, ma'am.
All right, state any evidence to support the plea?
State offer states one in attachment.
No objection, Your Honor.
All right, state, you may be excused. Did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there'll be no live testimony? Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same. All right, after reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
Yes, Your Honor.
Anything you wish to say on behalf of your client?
We'd ask the court to follow the agreement.
All right, why are you doing this? How old are you?
I'm 23.
All right, according to the police reports, you're causing disturbance at your parents' home and you're committing burglary of a building at this church. Why are you doing this?
So I go to that church at night because it's an amphitheater church and I just like to walk the stage and listen to music. That's what I usually do. I go there to free my mind at night. And it just so happened that the time that I needed to use the restroom, I saw that there was a door open. And I didn't plan anything. I just was just curious why the door was open. And it's just something that I know I made a mistake.
Well, I mean, you made choices that were not good choices.
Yes, that's right. But I was really just curious. I did not plan anything like that. And it's just something that I ended up walking into.
And then they said that there was money missing. They said there was money missing after you had walked into the church and left. So it's more than just walking and being curious. You understand?
I believe that's the mistake that.
Well, I mean, did you take money or not? Because they're saying that you walked in, there was money before you walked in, and when you left, money was missing.
Yeah.
$619.50. was reported missing from the church cafeteria. How far did you go in school?
I made it to the last month of my senior year. It
Why?
was a school in the country of North Dakota, in the very country there. It was a school where there's only 10 kids in my class.
Mhm.
And the same 10 kids attend that same school from preschool to their senior year. And so when I went back to my senior year there, they were really judgmental of me. I was my parents are part of the military, so I lived in a lot of different,
So let me ask you this, because there are a lot of people who have parents who are in the military. Your mom said that you have been causing disturbance at the home.
and I could tell you that my family that I've explained to that the way that my mom is being, they could say that a lot different of a story than what she's trying to.
Well, you're 23, you need to get a place of your own
That's
instead of living
because,
with your mom.
My bad for interrupting. I was 19 when I first got incarcerated. And I was recently released a few months ago. So that's the reason why I'm 23 and still there now, because I was 19 before I was incarcerated.
And what's with this teardrop?
It's for a lot of things. It's not anything bad.
What is it for?
I feel like I've been put into a lot of positions where I've been forced to burn a lot of bridges that I've had. And because of that, I've lost a lot of people in my life.
So here's the thing. I really don't have a problem with tattoos. People can do whatever they want to, but teardrops beneath the eye have certain connotations. I don't know why people start tattooing their face. If you want to tattoo your face, fine, but your job prospects are going to be limited. And it's going to be limited to maybe being an actor, maybe investing in concealer, maybe working with a band, or maybe who knows, there'll be some great person who will see past the tattoos. So what is his criminal history?
I believe he's currently on felony probation in another county jail.
All right, and what are you on felony probation for?
And aggravated robbery.
Ah, thank you. Now I know what's going on. This is why I ask these questions. So the court is finding him guilty. The court is going to sentence him to 198 days in the Bexar County Jail under 1244. Give you credit for any time served. There's $1,000 fine. Time and money will run concurrently. There's to be no contact and restitution, if any, to city, community, church. And the court will show that this judgment is satisfied so that the other county can come pick you up. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes, ma'am.
Because it's plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes, ma'am.
All right, good luck to you. You better do better. Otherwise, you're going to end up the rest of your life in somebody's prison. You understand?
Yes, ma'am.
All right, good luck to you.
Thank you.
Thank you. Who is here? Matthew Stephen Martinez.
I have Judge, I'm here for the.
He's in custody.
No, he's right here.
All right, come forward.
We're asking where's the first sitting? We're
You're on
asking-
this side.
We're asking the court for a reset.
So where are we on discovery?
I just started into the case, Your Honor.
All right.
I'll find out everything too later on today or tomorrow.
All right, State, have you uploaded all discovery? You think?
The state believes so, yes.
And can you make sure that there are no body cameras or dash cams that need to be uploaded?
It's better.
All right,
I
Ms.
viewed
Ferguson.
some of the information, they have some videos there already. I don't know if it's all of them, but they have videos.
All right. Norm, I need a 30-day reset for discovery on Matthew Martinez. All right, you're gonna come back on August 28th.
Thank you,
Once
Judge.
you sign the reset form, you're excused.
Thank you, Judge. Maybe excuse after that.
Yes.
Thank you.
All right, just have a seat, sir. All right, who is here on Emmanuel Moses Perez?
Judge, I'm here. Mr. Pettis is here.
All right, why was he late for court today?
He was in court 12 first.
Okay.
In fact, we still have to go back over this.
So court is at 9, okay?
Yes, but I had been checking that for 12, the next time over here.
So I always tell people, I never try to pull rank, but this is a felony court. Okay? All right, so there is a motion requesting the reinstatement of the bond. Why do I have this?
That should not have been.
That's probably mine, Judge. That's David Moses Escobedo.
Ah, okay. Thank you. Just give us a second and we'll take you up, Mr. Castillon. So on Emmanuel Moses Perez, let me look this up. Why does it have him listed as bond fugitive?
There was a bond increase on the misdemeanor.
Mm-hmm.
And then so when he came in here, he was picked up on that.
Okay.
And then I went down to 12 and was able to straighten that out. So that's been recalled.
All right. Let me just make sure it's in the Odyssey, because if it's not in Odyssey, he'll probably get picked up today. All right. So there's nothing here in the system.
Yes, he's been picked up one today, Judge. We'd like to avoid it being twice.
Okay. All right. So where are we on the discovery matters?
We are continuing to get things in through the civil case, but I've discussed all that with the state. The state's giving me everything they have. To the extent that I get things that are relevant, I'm gonna go ahead and hand it over to them when I get it.
Mhm. All right. So state, were you able to tender an offer?
Yes.
Okay. So Ms. Ferguson, on this case, I need a 30-day reset for a plea deadline date.
August 28th.
All right, August 28th. Once you sign the reset form, you're excused. And if y'all can make sure I have an acknowledgement of discovery before you leave.
For sure.
All right, and thank you for dressing appropriately for court.
And me?
Oh, yeah, that's a given. Esther La Fuente. All right, where are we on discovery?
Your Honor, we're good on discovery. The state relayed an offer today. I've conveyed that to the client. We do have some work to do on our end on witnesses, but that's where we're at, yeah.
All right, how old are you?
25.
All right, Ms. Ferguson, I need a 30-day reset for a plea deadline date.
August 28th, Judge.
All right, August 28th.
Thank you, Your Honor.
Once you sign the reset form, you're excused, okay?
Thank you, Your Honor.
All right, and thank you for dressing appropriately for court. Orlando Castillon,
Yes, Judge.
on David Escobedo. What is the issue with the bond?
So I spoke with the bond company and I think the clerk had said that because the bond had already been closed out, that they couldn't restore it. So I was going to ask that you just set the bond amount at the previous amount. And the bond company said they would be posting a new paperwork for the bond.
All right, state, any objection to the previous bond on Mr. Escobedo? Just one moment. I'm sorry, it's taking a little bit while for Odyssey to open documents for me.
Did not see him on our doc.
Yeah, it said bond increase, it was at 20,000, Judge. That was on February 10th of 2025.
There was subsequently, though, a motion to reinstate bond, which happened. And so I believe the previous bond was actually still 10,000.
Let me, I'm looking for it here. Just one moment.
Yes, Judge.
If not, I can print it out, Judge, if you want.
All right, the previous bond was $10,000.
And you Steve asked in reference to what we thought was an original increase to 20, what the reason, if it wasn't increased.
It was, I think it was increased by another judge, not by me. I didn't increase it to 20,000.
It was increased, I think, under Nahara, Judge Nahara. He had gotten to compliance with ignition interlock, and the judge reinstated the.
I think the state would recommend doubling the bond if the issue would have been the ignition interlock.
That's not why this bond was. That's not why there was a warrant issued here previously.
Oh, let me ask you this. So I see that the original bond was $10,000. And then there was a bond increase on February 10th, 2025. And that's the bond that was made by the defendant, correct?
I believe it was reinstated
Yeah. These are all.
because he became in compliance with his ignition interlock. I think he had not had it installed.
All right, the only thing is I don't see that on the system, council. I just see his bond was at $10,000 originally. And then it was increased to 20,000. So Norma, can you check to see if he made the bond of 20,000 or 10,000?
Yes, ma'am.
And so we'll find out which one it's supposed to be, council.
Okay, Judge.
All right, while they're looking for that, Mr. Roberto Ambrosino,
Yes, Judge, I'm here.
you're here for Carlos Perez.
Yes, Your Honor.
All right, Carlos Perez, if you come up, please. Okay. All right. So on this case, the offer was tendered, correct?
Yes.
Today, yes. Counsel?
Yes, Your Honor. I have conveyed it to my client. He is not willing to accept it at this time.
All right, Ms. Ferguson,
Yes, ma'am.
set this for a jury trial. It should be short. It's a fraudulent possession of identifying information. So with jury selection, it should probably take a day.
Yes, ma'am.
Do you want a jury trial or a bench trial?
What's the difference?
Jury trial, Your Honor.
Great.
All right, a bench trial is where evidence is presented to me and I make a decision on whether you're guilty or not guilty. What I can tell you is if the state proves this case beyond a reasonable doubt, I'm going to find you guilty. If they don't, I'm going to find you not guilty. A jury trial is where 12 citizens will sit and they will listen to the evidence and they will make a decision. So your attorney is saying that you wish to have a jury trial. Is that correct, sir? Mr. Ambrosino, is that correct?
Yes, Your Honor.
All right, Norma, I need a quick turnaround for a jury trial on this, please.
Is September 23rd okay, Judge, or you want something? sooner?
Yes, September 23rd will be your jury trial date.
Thank you, Judge.
Once you sign the reset form, you are excused.
Thank you, Judge.
Your plea deadline date has expired. The court will not accept any plea bargain agreements in this case without good cause. Otherwise, you have to plea open to the court. Do you understand?
Yes, yes.
All right. Well, I mean, is there something you don't understand?
Well, yes, I do.
All right, if you don't understand, let me know.
Thank you.
All right, just remain and they'll give you a reset form to sign.
Mr. Pettis, come here and grab.
Thank you, Judge.
You're welcome.
And sign where it says
Thank you,
defendant.
Judge. May I be excused?
Yes.
Thank you.
All right, so do we have an update on Mr. Castellon's client, Escobedo? No. I mean, they're supposed to tell me what the bond amount was.
Oh, Judge, it looks like he did make the bond at 10.
All right. So state,
Yes.
I believe that Judge Nahara put the bond at 20,000, but then once he obtained the ignition interlock or whatever he needed, the judge put the bond back at 10,000.
The state would still be of the mindset that bond is privilege, and if there were something that resulted in a revocation, we would recommend doubling. State won't decide if it's put at 10, but we would recommend double.
Okay. All right, so Mr. Castagnon?
Yes, Judge. My understanding is the court was intending to reinstate this bond.
No,
And-
I'm not asking you for further argument.
Okay.
I know the reason why his bond, the reason he was taken in custody. The defense sent a motion to reinstate bond to the state. And it was filed with the court. The court has reviewed that. The court is understanding that there will be no more disruptions from your client. The court will set the bond at $10,000. There's to be ignition interlock on any vehicle the defendant has access to. And there's going to be 30 sober meetings in 30 days. And And counsel, where are you? Do you have all your discovery or no?
I have received discovery. I received blood discovery. I need to get that reviewed. And we were given an offer today. I relayed that to my client. And we don't have we have not really had an opportunity to discuss the offer.
All right, Ms. Ferguson, I need a plea deadline date in 3 weeks.
It is August 19th.
All right, August 19th.
Okay, Judge.
Set
Got my
form,
calendar.
please. Thank you.
May I be excused, Judge?
Yes.
Thank you so much.
All right, Mr. Hicks, who do you have? All right, the court is calling 2025 CR 007538, State versus Elijah Rodriguez. Can I have parties announced?
Andrew K. Hicks for the defense.
And are you Mr. Rodriguez?
Yes, ma'am.
Counsel, have you received all discovery? Did you review that with your client?
I have, Your Honor.
Court will find that the state is in compliance with discovery. All right, off the record for a moment. Do y'all have the true bill of indictment? And is there an application in this case?
There's not.
All right,
No, Your
Mr.
Honor.
Rodriguez, did you review the true bill of indictment with your attorney?
Yes, ma'am.
Did you understand it?
Yes, ma'am.
Oh, I found it. It's for the papers.
Okay.
Your Honor, in regards to the true bill of indictment, the state does have an oral amendment.
Okay, just one moment. You reviewed that with your attorney?
Yes, ma'am.
Defense, do you waive the reading of the indictment?
We do, Your Honor.
State, are you proceeding on the indictment as presented?
We are, but with an oral amendment.
Yes.
That has been spoken to defense. When you look at the indictment, at the bottom, it says, and this was to enhance to get jurisdiction in cause number 2023 CR 009809. That should read 2024 CR 009809.
Any objections to that change?
No objections, Judge. It looks like it was just a clerical error. I did confirm it with my client.
All right, and Mr. Rodriguez, you understand that that's a substantive change to the indictment?
Yes, ma'am.
And knowing that, do you still wish to proceed with that change?
Yes, ma'am.
Did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
All right, you're charged with theft of property, 2,500 or more. I'm sorry, less than 2,500 with 2 or more previous convictions. That's a state jail felony. Range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to a $10,000 fine. If you have a plea with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand? You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses. The state would call in the right to remain silent. By entering this plea, you're giving up those rights. Did you intend to give up those rights and enter into a plea in this case? You need to say yes or no.
Yes.
Counsel, has your client been able to provide you with any defenses?
He has.
Do you believe he has a rational as well as a factual understanding of the charges against him?
I do believe so, yes.
Do you believe he's currently competent and was legally sane at the time of the offense?
I do.
Mr. Rodriguez, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Anyone promised you anything other than the plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen?
Yes, ma'am.
Court will find that the defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, ma'am.
According to the plea, punishment is to be assessed at 8 months in the state jail facility. The state will take in consideration 2025 CC 005803. There's to be restitution, if any, to Home Depot and no contact with Home Depot. Did you understand that to be the plea?
Yes, ma'am.
Defense, is that the plea?
It is, Your Honor.
State, is that the plea?
Yes, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes, ma'am.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, have there been any such motions?
None, Your Honor.
Then to the offense as charged, how do you plead? Guilty, not guilty, or no contest?
No contest.
State any evidence.
State offered states exhibit 1 and all attachments at the center.
No objections.
Okay. Did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call, and the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there will be no live testimony. Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments. Court has reviewed the same. The court will find there is sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
Yes, Your Honor.
Anything you wish to say on behalf of your client?
We just asked that the court follow the plea bargain agreement, Judge.
All right. So, Mr. Rodriguez, why do you keep doing this? What's going on in your life?
I'm gonna be very honest, Khalid. I'll like to be sent to a rehab because I do have a low drug addiction.
All right, and what drug might this be?
Climax,
I'm sorry, what?
synthetic marijuana.
Okay. All right. So here's the thing. I believe, and I could be wrong, but I believe your attorneys have reached this agreement because of the number of priors you have. State, I don't know if you all want to reconsider the plea bargain agreement. The defendant is saying that he wants rehab. But I don't know, I haven't looked into your complete criminal history because I'm being objective and keeping an open mind.
Your Honor, history was part of the state's offer and recommendations.
Okay.
And like mine have gotten us to this point.
Okay. All right, this is what I'm going to do. I'm going to follow the agreement. Going to sentence you to 8 months in the state jail facility. Give you credit for any time served. There's to be restitution, if any, and no contact with Home Depot. I'm going to order the therapeutic community for you. I can't force them to place you in the therapeutic community, but they're going to see in the judgment that I'm requesting that for you. All right. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand that?
Yes, ma'am.
All right. Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes, ma'am.
All right, we can go off the record. Here's the thing. If you're serious about wanting help for your drug problem, when you're released from the state jail facility, if I'm still here, you come back in here, I will pick up the phone for you and I will find a place for you that will take you inpatient, okay?
Yes, ma'am.
But it's going to be completely up to you. All right?
Yes, ma'am. Thank you.
All right, you're welcome. Good luck to you, okay?
Thank you. God bless you.
Oh, thank you. God bless you too.
Thank you, Your Honor. May I be excused?
Yes. Alfredo Campos. Is this a plea?
Yes, Your Honor.
All right, can I have a file stamp for a plea, please? Court is calling 2025 CR 0022720 State versus Alfredo Campos. Could I have parties announced?
In the state of Texas.
Renee Munoz on behalf of Mr. Campos.
All right. Counsel, you received all discovery. Did you review it with your client?
Yes, Your Honor, that's correct.
Court will find that the state is in compliance with discovery. Is there an application?
No, Your Honor.
All right. Mr. Campos, did you review the true bill of indictment with your attorney? Did you understand it? Counsel, do you waive the reading of the indictment?
Yes, Judge.
State, are you proceeding on the indictment as presented?
We are still proceeding. Additionally, Your Honor, state will waive the repeat offender enhancement. Also no objection.
Okay. All right, did you review the document entitled court admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, sir.
All right, in count 2, you're charged with assault family household member with a previous conviction. That's a 3rd-degree felony. Range of punishment is anywhere from 2 to 10 years in prison and up to a $10,000 fine. If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, sir.
You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent. Did you understand by entering this plea, you were giving up those rights?
Yes, sir.
And did you intend to give up those rights and enter into a plea in this case?
Yes, sir.
Counsel, has your client been able to provide you with any defenses?
Yes,
Do you believe he has a rational as well as a factual understanding of the charges against him?
in my opinion, he does.
Do you believe he's currently competent and was legally sane at the time of the offense?
That is correct, Judge.
Sir, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea? Anyone promised you anything other than the plea? Are you satisfied with the way you've been represented?
Yes, Your Honor.
Are you a U.S. citizen?
Yes.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes.
According to the plea, punishment is to be assessed at 3 years in the prison. There's a $1,500 fine. State is proceeding on count 2. There's an affirmative finding of family violence. There's to be no contact with the complainant. Did you understand that to be the plea?
Yes, sir.
Defense, is that the plea?
Yes, Judge.
State, is that the plea?
It is, Your Honor. I did want to mention that when you get to the stipulation.
Right. Did you understand with an affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition?
Yes, sir.
And you're not allowed to be designated as primary custodial parent?
Yes, sir.
Right. Knowing that, do you still wish to continue with this plea?
Yes.
Right. Did you review the waiver of appeal paragraph with your attorney?
Yes, sir.
Did you understand it and sign it in both places? Did you understand it and sign it
Yes.
in both places?
Yes.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, sir.
Counsel, are there any such motions?
No, Judge.
Then to the offenses charge, how do you plea in count 2? Guilty, not guilty, or no contest? State, any evidence?
This time state the evidence, states exhibit 1 with all attachments. No objection.
Right, did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, sir.
Again, did you understand you have a right to a jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent?
Yes, sir.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes, sir.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments. The court has reviewed the same. Court will find there is sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
Yes, Your Honor.
Anything you wish to say on behalf of your client?
We're asking the court follow the negotiated plea bargain agreement, Your Honor.
All right, so what is wrong with you? This is a person, for whatever reason, decided to pick you up from custody when maybe she should just let you stay in there, for whatever, and let you just stay there. She takes it upon herself, and I'm sure she paid your bond, and she picks you up and brings you back home, and then you beat her up. What's your issue? Yeah, I mean, you do, because somebody do you love her, or do you claim to love her?
No.
No, you don't, because that's not the way you treat people you love. She took it, probably money from her children, to pay to bond you out, and then, all right, let me tell you what's in the police report, and you tell me what's incorrect about this. I asked victim what happened. Victim stated the following events occurred. Since Wednesday, she went to pick you up from the jail. She stated they were good, no problems. Later that day is when the defendant began to strike and choke the victim. So this is where we are.
Or I don't know if, I think he just got a little bit tangled up. I don't know if he bonded out or if he was just released at that point, and then she picked him up instead of the bond. I think that's where he was a little confused.
I was just confused because I was released from my stuff, not from the county.
Oh, okay, so there was no bond posted. Okay, that's what I think.
So here's my question. Is the reason for this offer because the complainant does not want to participate and has filed an affidavit of non-prosecution? All right. So she's filed an affidavit of non-prosecution, even though I'm looking at the photos, she has a black eye, she has bruises on her arms, and she took time out of her busy schedule to come pick you up from wherever you're incarcerated. So for some reason, she's attached herself to you, but I'm going to try to break that cycle today. So I'm going to sentence you to 3 years in prison. There'll be credit for any time served. There's a $1,500 fine. Time and money is not running concurrently. There's an affirmative finding of family violence. There's to be no contact with Ana Maria Hermio, AKA Ana Maria Gonzalez, and you're not allowed to reside in any residence with minors. Do you understand? Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes.
Because this is plea bargain agreement, because I followed this plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction and also affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition. We can go off the record. Here's the thing. Don't get involved in any other relationship. Don't contact her. If you love her, the best thing you can do for her is not contact her, because you're not any good for her. And until you figure out why you feel the need to put your hands on people in anger, you should not be in anybody's relationship. Here's my advice to you. Get an orchid. I always tell people that, and this is why I tell people to get an orchid. An orchid takes a lot of patience. When you get it from the store, it's beautiful. They all have them all with the flowers bloomed on it. They will give you directions. Those directions don't work. I learned you're not supposed to put ice cubes in them. But if you can let the blooms fall off of that orchid and keep that same orchid and get it to rebloom, you may be ready for a relationship, because with orchids, you have to learn patience. You understand? All right, good luck to you.
Thank you.
You're welcome. Court is calling 2025 CR 00717 State versus Desmond Gomez. Can I have parties announce?
Good luck for the state of Texas, Your Honor.
Christian Vega for the defense.
And are you Mr. Gomez? Counsel, have you received all discovery? Did you review it with your client?
Yes, Judge.
Court will find that the state is in compliance with discovery. Mr. Gomez, did you review the application for community supervision or deferred adjudication with your attorney? Did you understand it?
Yes, Your Honor.
Did you review the true bill of indictment with your attorney? Did you understand it?
Yes, Your Honor.
Counsel, do you waive the reading of the indictment?
I do, Judge.
State, are you proceeding on the indictment as presented?
We are, Your Honor. However, the paperwork before the court, because there will be a plea on all 3 counts, there's paperwork specifically for the attempted taking weapons state jail, and then paperwork for the 2 third degrees. They are from the same cause number, but because they were different levels, we are proceeding as charged, but that is to make sense of the paperwork before you.
Okay.
In the way it was indicted, count 1 and count 3 were harassment, count 2 was attempted, so I hope it makes sense.
Oh, no. Let me see here. All right, thank you. All right, so Mr. Gomez, in each of the cause numbers, did you review the court admonishments and defendants' waivers and affidavit of admonitions?
Yes, sure.
All right, in counts 1 and counts 3, you're charged with harassment of a public servant. That's a 3rd degree felony. Range of punishment is anywhere from 2 to 10 years in prison and up to a $10,000 fine. And in count 2, you're charged with attempting to take a weapon from an officer as a state jail felony. Range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to a $10,000 fine. If you have plea bargain agreements with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you, and you will be allowed to withdraw your plea. Do you understand?
Yes, Your Honor.
In each cause number, you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses. The state will call in the right to remain silent. By entering this plea, you're giving up those rights. Did you intend to give up those rights and enter into a plea
Yes,
in
Your
this case?
Yes, Your Honor.
Did you understand that the court were to grant your application for deferred adjudication if for any reason your deferred adjudication were revoked? And counts 1 and 3, the court could sentence you up to 10 years in prison and up to $10,000 fine. And count 2, the court could sentence you up to 2 years in the state jail facility and up to a $10,000 fine.
Yes, Your Honor.
Counsel, has your client been able to provide you with any defenses?
Yes, Judge.
Do you believe he has a rational as well as a factual understanding of the charges against him?
I do.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, Your Honor.
Mr. Gomez, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, Your Honor.
Anyone promised you anything other than the plea?
No, Your Honor.
Are you satisfied with the way you've been represented?
Yes, Your Honor.
Are you a U.S. citizen?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. And each cause number, did you review the plea bargain pages with your attorney? Did you understand them?
Yes, Your Honor.
And count two, the state, I'm sorry, in each count, the state is recommending deferred adjudication. The counts will run together. There's to be taken in consideration 2025 PF 13273. There's to be restitution, if any, and no contact with the complaining witness. TAP evaluation, follow recommendation, anger management, and MRT. Did you understand that to be the plea?
Yes, Your Honor.
Defense is at the plea?
Yes, Your Honor.
State is at the plea?
Yes, Your Honor.
Did you review the waiver of appeal paragraph with your attorney in each of these counts? Did you understand it and sign it in both places?
Yes, Your Honor.
Did you understand by signing that you're waiving your right to appeal? And the only, just 1 second. I'm reading something else about this. All right, did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, Your Honor.
Counsel, have there been any such motions?
No, Judge.
Outside the agreement, in count two, the state is asking that your length of community supervision be 5 years. In counts 1 and 3, they're asking that your length of community supervision be for 7 years. There's 200 hours of community service restitution and no contact with the complainant. Did you understand those were recommendations from the state and the court does not have to follow those recommendations?
Yes, Your Honor.
Then in count 1, how do you plea?
Guilty. Oh, no contest, Your Honor.
Count 2, how do you plea?
No contest, Your Honor.
Count 3, how do you plea?
No contest, Your Honor.
State, any evidence?
State offers State's Exhibit 1 and all attachments in both of the plea paperworks which have the same cause number.
All right.
No objections.
All right, did you review the waiver and consent to stipulation of testimony and stipulations with your attorney? Did you understand it and sign it in all the appropriate places? Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes, Your Honor.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there will be no live testimony. Did you understand?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence State's Exhibits 1 and attachments, and the court will review the same. All right, after reviewing State's Exhibits 1 and attachments, the court will find there's sufficient evidence to find you guilty of counts 1, 2, and 3. The court will defer finding of guilt as you've applied for deferred adjudication. And actually, counsel, I'm sorry, could I have the trial court certification back?
Yes, Judge.
All right, so what I'm going to do based upon what I'm reading in the report, yes. Oh, okay, I thought you were saying something. I am going to set this for a TAP evaluation and a mental health evaluation. Is anyone requesting a PSI? I really don't need the PSI. I need the TAP evaluation done and I need the MIC evaluation.
That's fine, Judge. And we had discussed that, but we didn't make it part of the agreement, the
Okay.
MIC.
All right, Miss Norma, it's just for a MIC evaluation and a TAP evaluation. Is there any way to expedite that? Vashawn, you shaking your head, no?
Okay.
All right, so we're gonna come back on September 16th.
Okay, Judge.
All right, and I know that's a long time, but that's the earliest we can get you in. And it's really better that this be done as opposed to me just sending you out into the world, not knowing what's going on with you, okay?
Okay.
All right, thank you.